This is my criminal trial system PowerPoint. The right of the defendant, the bail. There is a doubt about the suspect's name and address. Police feel that the suspect may interfere with the witness or the evidence. Police feel the suspect needs protection from someone else. And the police feel that the suspect will not attend court and will violate this. And the legal representation, the community legal service. You can also apply for help. Only a limited amount of money, and when it runs out you get no assistance from the Criminal Defence Service, and this is legal aid. All those involved in criminal proceedings have the right to advice, assistance and representation. The criminal trial, a summary offence. Summary offence can only be dealt with within the magistrate's court. Usually summary offences are considered less serious and are sanctioned by a 6-month prison sentence and or a £5 fine. And summary offences include minor assault, driving without insurance, indecent exposure, and taken without owner consent. Then there's the indictable offence. Indictable offences appear in the magistrate's court first, but then are committed automatically for trial in the Crown. Generally these are the most serious offences and are sanctionable able up to life imprisonment. These offences include the obvious ones like murder, manslaughter, rape, blackmail and aggravated burglary. Then the power of the courts. The magistrate's courts sentencing powers and they have limitations. They can sentence a person for a summary or trial either way offences with a max of 6 months in prison and or £5 fine. On the other hand, the magistrates handed out very clear guidelines on how to sentence. They're given by the Sentencing Guidelines Council, which tries to ensure the sentencing remains consistent. The fines that can be imposed can be level 1, 2, 3, 4 and 5 from £200 to £5,000. Crown Court sentencing powers are different from the powers of the magistrates. The Crown are able to sentence more serious offences, but again must take the consideration guidance Sentencing Guidelines Council. All offences have a maximum penalty which is set out in the law. There are a range of penalties available to the judges in Crown Court, including fines, community sentence, custody and a suspended sentence. Indictable offence. An example, you can get the murder, the elements of the first degree. The state laws categorising murder into first, second and possibly third degree. Willfulness, deliberation and premeditation. Crown Courts. Crown Court sentence powers are different to the magistrates. It's the same thing, it's similar. Go again, that's the same. This is comparing magistrates and Crown Courts. Magistrates Court deal with less serious crimes, summary offences and some either way offences, whereas the Crown Court deals with very serious and traumatic cases. Also, Magistrates Court is rather cheap when comparing to the Crown. Another big difference is that the Magistrates Court do not use a jury, but a jury is essential for a Crown Court. Magistrates Court runs out rather quickly compared to the Crown Court, which can be quite drawn out due to numerous hearings. The Crown Court has much more complicated proceedings than the magistrates. On the other hand, a similarity of these courts is that they have similar roles, e.g. the judges, and another similarity is that they both have good conviction rates. Magistrates is 90% and the Crown is 83%. In the grounds for appeal, you have the right to appeal against decisions of the Magistrates Court. If you were found guilty at trial, you can appeal to the Crown Court to tie against your conviction. However, if you plead guilty and were sentenced in the Magistrates Court, you'll not be able to appeal against your conviction, but you can still appeal against your length or nature of the sentence. You must provide a prosecutor with notice so you can appeal your conviction or sentence within 21 days. It's possible to apply the Legal Service Commission for legal representation of your appeal. The Crown Court will give you a date and you must attend for your appeal, which will be heard by 2 magistrates and a Crown Court judge. There is no jury, but your entire case will be heard again. If your appeal is against sentence only, the prosecutor will tell the court details of your conviction and your lawyer will then tell you in relation to the offence itself. If you appeal against conviction, the witness who gave the evidence at the original trial in the magistrates will be required to give evidence once again. However, it's important to take note that as well as quashing a conviction and reducing sentence, the judge and magistrates are also entitled to impose harsher or different judges and sentences, and may also make you liable to pay prosecution costs if they consider that you shouldn't have brought the appeal in the first place. There's no further right or appeal, and after that you have appealed the Crown Court from the Magistrates' Court. And that was my presentation.